call to order this meeting of our, let's see, what is our official name? The Water and Natural Resources Subcommittee of the House Bill 3000 Task Force. I'm truncating the name of the overall task force because it's very long and complicated. Our subcommittee's mission here is to really look at water and natural resources issues involved in the cultivation of illegal hemp and cannabis. And a number of assignments were given to us in House Bill 3000 and the subsequent Senate Bill 1564. So this is our second meeting. We want to welcome everyone, and for the benefit of our guests, and since there aren't too many of us here, let's just do a quick run through of introductions so that you'll know who's in the virtual room. And I'll start. I'm Pam Marsh. I'm the state representative for District 5, which is Southern Jackson County, where the issues around illegal hemp and cannabis have been a huge public concern. So thank you to our guests here for being here today. Lauren, are you on now?
I think he's still on the other call.
Oh, okay. How about Jake?
Jake Johnstone's here by virtual Teams for Water Resource Department.
Great, thank you. And Matt?
Yeah, Matt Cyrus. I'm a farmer over in Sisters, Oregon.
Great. And Beth, I don't know if you are able to introduce yourself, but if you'd like to.
I am Beth Petrino, working with the Legislative Policy and Research Office and currently staffing the Senate Natural Resources and Wildfire Recovery Committee.
Great. And Sunny?
Good morning, Sunny Summers. I'm a senior policy advisor to Director Taylor at the Department of Agriculture.
And Patrick?
Good morning. I'm Patrick Aitchison at the Oregon Department of Justice, a senior assistant attorney general in the Environmental and Cultural Resources Enforcement Unit. We call ourselves ECRU for short, but some people say ECRU. We say ECRU, I say Aitchison, so we'll do our best together.
Great, thank you. And Jordan.
Good morning, everyone. My name is Jordan Bailey. I'm an assistant attorney general with DOJ. I'm the newest member of the ECRU team. I've been here for about 8 months. Prior to that, I was a Jackson County Deputy District Attorney for 6 years. So recently coming from Southern Oregon and intimately aware of the issues that that are the reason we're here today.
Right. Thank you. So you all, Jordan and Patrick, are really the main event here today. In our first meeting, one of the questions that we really wanted to address is whether or not we have appropriate, basically, crimes on the record and the ability to enforce follow-up of those crimes when we see the environmental impacts of these illegal operations, which can be very extensive in terms of water, in terms of toxins on the ground, in terms of pesticide use, in terms of just the junk that's left when an operation folds or the operators move on. So appreciate you here today to tell us how you see this and whether or not DOJ would have recommendations for any kind of changes that we should consider. So with that, I'm going to just hand it over to the two of you to educate us. And Sunny, we are recording. Okay, great. Take it away.
All right, thank you very much. I'm going to go ahead and share my screen. We have some slides. Can everyone see that okay?
Mm-hmm.
Okay. Patrick, do you want to go ahead and start us off?
Certainly. Thanks, Jordan. What I would say, and this may be familiar to members of the subcommittee, Oregon has a body of laws that provide for the criminal prosecution of environmental and cultural resources offenders. These laws relate to air and water pollution, hazardous waste, fish and game offenses as well, along with the laws that address damaged, looted, or destroyed archaeological sites, artifacts, and other objects of cultural significance. And I think proper and effective employment of these laws requires familiarity with each of the unique statutory schemes and a familiarity with the enforcement landscape, which often involves both criminal and civil penalties. And ECRU utilizes our specialized expertise to serve as a resource for district attorneys' offices around the state and the state agencies, primarily DEQ, but also the Department of Agriculture, DSL, ODF and W on the environmental side, but SHPO, state parks, and the 9 federally recognized tribes on the cultural resources side. And of course, we're a resource for the people of the state of Oregon. I don't make it a practice to speak for Jordan, but I would say that we consider ourselves very fortunate to have been given the opportunity and the latitude to sort of pursue these non-traditional criminal cases in the environmental and cultural resources area. And we remain excited about working collaboratively with the subcommittee and appropriate agencies on dealing with issues related to cannabis enforcement. I think we've done good work at ECRU, and our successful prosecutions and resolutions are a measure of that. But more importantly, we have a solid relationship with our district attorney's offices around the state. Our law enforcement partners, primarily OSP and EPA, and the various agency directors and staff, tribal leaders, and many legislatures. As you all know well, relationships are paramount and will be the key of ECRU's future success. And we have been thrilled to work with Sunny and ODA collaboratively on our monthly meetings, related to these issues. What I would say is, environmental enforcement is unique in that it's the only area of prosecution that's so uniquely tied to civil enforcement. A quick review of the environmental crime statutes, followed by a review of the civil and administrative enforcement avenues demonstrate this. Under the law, the same conduct by an offender can result in a notice of noncompliance, a civil penalty, or the filing of an information or an indictment in the criminal realm. And this very fact has led to significant concerns within the regulated community upon the passage and led to the passage of the Oregon Environmental Crimes Act. As a result, we have additional considerations and filing requirements that are uniquely associated with environmental prosecutions that are statutorily incorporated into that Environmental Crimes Act. This paradigm exists in no other area of criminal prosecution, but in short, environmental prosecutions properly lie somewhere between criminal prosecution and civil enforcement. So we sometimes wear both hats, and we work with agencies that also have existing civil authority. That is a common fact pattern for us to be in. So from there, Jordan, do you want to talk a little bit about some of the statutory provisions we most commonly use and how they might relate to this interdisciplinary work related to cannabis?
Yeah, I'm happy to take it from here. Thank you, Patrick. And just to clarify, this is obviously not legal advice, something that we have to preface in these types of presentations. But we're here to obviously review with the committee the existing statutory scheme that we work with as we've approached this issue. The General Oregon Environmental Crimes Act is ORS 468920 to ORS that's supposed to be 468, excuse me, 963. As Patrick stated, the inception of this statutory structure came about essentially to ensure that Oregon was meeting its responsibilities under the delegated authorities from federal environmental statutes. This has been in place for some time now, but that unique structure came about when this act was working its way through the legislature. Legislators and business communities voiced concern about the possibility of prosecutorial overreach. They wanted to make sure that such statutes were applied consistently, and also wanted to make sure that there was the ability to have clarity in terms of what constituted a crime in this realm. And within our Oregon Environmental Crimes Act, ORS 468961 is the embodiment of that compromise. Essentially, this the first requirement under this statute essentially says that unless there is exigent circumstances, no person shall be charged with a felony under the Environmental Crimes Act without the personal approval of the district attorney of the county or the attorney general of the state of Oregon. How that comes into existence is clarified in the later subsections of that statute. I'm not going to read this entire thing, but I will display it here. And just to preface all of this, we're going to be cruising through a body of law that has a lot more detail than I think we can cover in this particular session, and we want to make sure that we're being time efficient. But if there's any follow-up or any other clarification that the group wishes, please not only ask questions, but reach out to us at any point. We're a resource for everyone here as well. So in order to promote that consistency and bring in those criminal prosecutions, the district attorney shall adopt written guidelines for filing felony criminal charges under the Environmental Crimes Act. And they have to weigh essentially certain factors and show that they have applied those factors in determining whether or not they're going to file criminal charges. In looking at this list and as we've thought about how this may apply to cannabis prosecution, some of these things may or may not apply to the types of cases we see with illegal cannabis, but there are specific factors that do weigh in this. And these factors, many of them mimic the types of decisions that any prosecutor is going to be making when exercising prosecutorial discretion, the weighing of history, the weighing of the severity of the action, that type of thing. But the language is specifically written and was written with the original Environmental Crimes Act lens in mind, which is essentially regulated communities acting far outside of their regulatory responsibilities and or just particular bad actors. But as we have been learning and communicating with our partners, we do believe that there is many opportunity to apply these things to illegal cannabis, and this is just the lens that brings this about. So some of the things that we think that do and don't apply that we want to kind of highlight are the magnitude and probability of the actual potential harm to human environment, the extent to which the person was or should have been aware of the requirement violated. Obviously, in the illegal cannabis context, many of these folks are obviously approaching these situations without any intent to abide by any regulatory construct. So if they're not complying with the legal cannabis structures, they're certainly not going to be thinking about their responsibilities to DEQ or to ODA or any other state agency. Things like the history of repeated.
Yeah, I think Jordan makes a good point here, and a thing to think about for the subcommittee. You know, when we have a nascent industry like this, and as such, we're building an enforcement program, and you know, the agencies present as a part of this subcommittee are going to have existing civil statutory authority, as well as these criminal provisions that Jordan's going through. You know, we have models for what works in other contexts, and you know, we think about whether a case is appropriate for, you know, civil authority to be exercised or criminal provisions. And you know, things we think about are, you know, is there a clear violation of the law, or is it something that's more ambiguous? You know, is there a history of non-compliance by the person, which indicates that the administrative enforcement, the civil process, isn't reaching the needed result? You know, was the violator, you know, was their conduct deliberate and deceitful and dishonest? That sort of tends more towards the criminal realm. And then, as Jordan was saying, you know, something that results in significant damage to the environment or human health. That lands you more in Jordan and my shop when we think about what lane of enforcement's appropriate in order to gain compliance.
Thank you, Patrick. That's an extremely important addition to this, and really boils down to why we have started to explore and reach out to partners that deal with illegal cannabis prosecution, because in thinking about these factors and in thinking about the types of actions in the state that essentially would constitute the types of sort of either egregious action and or far non-compliance with whatever responsibilities they have. This is why the illegal cannabis activity, especially as we've learned more and more about what is happening on some of these grows or in some of these operations, has at least brought it to our attention to the point where we are doing such a deep dive in whether or not and how our existing work can apply to this realm. Like I said, multiple factors to look in here. Just a finish this process, the Attorney General was also required under statute to pass a model guideline for these same factors, and it was indeed done, and it can be found at OAR 137-095. 0010 through 0030. Essentially, what this statute does create for us is a responsibility to not only discuss when we reach out to our DA partners when one of these cases is coming about, to not only make them aware of this responsibility and this requirement, but also to discuss the case through this lens to make sure that, as Patrick said, indeed, that prosecution in the criminal sense is the appropriate avenue for whatever case it is that we're reviewing. So in this sense, while it seems like a dubious sort of extra hurdle to go through, and many DAs don't either know or frequently deal with this responsibility, one of our assets is that we have the ability to walk through with them what this actually means, that it's not a complicated requirement to do, and in fact it's an exercise of their prosecutorial discretion in a way that they are already equipped to do, and we just make sure that it's something that they are considering. An important note, though, is that this does not apply to misdemeanors. While we in our shop do consider these factors with any case that we're doing, it's a part of our analysis as we figure out what is appropriate for us versus what may be better suited by some sort of civil action. The filing of any certification is not a requirement. So that does have relevance in this cannabis context, because as the committee is no doubt aware, the traditional charges that are going to be levied against someone who's engaged in illegal cannabis activity are part of now ORS 475C and unlawful manufacture of marijuana, charges like that. What this does, what the filing of these charges does, is opens up the opportunity to have a narrative in a trial or in the case that involves this activity, to not only describe the illegal drug activity, which is something that obviously those who prosecute these cases are already aware of, but can show juries and judges that this is not important just because it's a drug problem. It is important because there are things happening on these sites that degrade public lands, that degrade water sources, that obtain a water illegally, that use harmful chemicals and pesticides, and as we've learned, any other litany of awful things that that pair with the actual drug crime itself. So I'm going to start walking through the statutes that we have and would think most apply to the cannabis realm. I'll move pretty quickly. And again, if there's questions, I can always return to this.
Jordan, can I ask a quick question first?
Of course.
First of all, I'm glad to know that there's a model statute, because that certainly would expedite the adoption at a local level. Have all of our DAs done this job of creating guidelines?
Our understanding is no. There are some that have, when these cases have arisen in their counties, have included it in their policy manuals, especially given that some of them have had, because of other statutory requirements, have updated those policy manuals, and or counties that have dealt with these on a more frequent level. Counties like Multnomah obviously have some of these things in place, but we have realized that smaller counties have either not had a case that has risen to the level of criminal prosecution such that they've addressed this, and or it's our understanding, as we've looked in cases in the past, that when one has arisen, a DA will adopt it essentially for the purpose of the individual case, and that can be valid and fine. But for us, in one of our missions, as we've sort of addressed what we could do better in our unit, is to work with the county DAs to try to more uniformly have them adopt it. We're in the process of reaching out to many of them and having that conversation. But it's a work in progress. Elected officials obviously change frequently, and we want to make sure that we're explaining the full extent of why this is important, and that it's not necessarily a sign that you have one of these cases, that it's easier to deal with in the front end, so that consistency is important. So to answer your question, Rep. Marsh, know that they haven't all officially adopted it. So that's something that we deal with when one of these cases is sort of making itself known.
Got it. Thank you.
And thank you for that question. That's an excellent question. I bring up this, I'm going to put a couple of definition statutes. This is important for our environmental context because it adds within this Environmental Crime Act an additional definition of knowingly. So this subsection A is the traditional definition of knowingly that any criminal case is going to have to deal with when that is the mens rea element in that charge. But subsection B is an important one for a lot of our context and may come up in the illegal cannabis context as well, which is knowingly can also mean that a person acts with a conscious purpose to avoid knowledge of a conduct or circumstance in violation of those parts are not important, but the rest, it's essentially the body of environmental laws there. So if someone's taking steps to willfully shield themselves from a responsibility to know something that is going on, then that opens a possibility of these types of prosecutions as well, and is something that, especially in our the more traditional regulated entity context, comes up, but could potentially have application in this realm as well. Same thing for these type of statutes. The Environmental Crimes Act adds a couple ripples to the definitions that give us more clarity as it applies to environmental issues. So again, substantial harm to the human health or the environment, which you'll see in some of the statutes that we bring up later, means both physical injury that is defined again by the traditional criminal definitions to a human being, or a demonstrable substantial risk of serious physical injury, again, as defined in the traditional criminal definitions, but also substantial damage to wildlife, flora, aquatic or marine life, or to habitat, livestock, or agricultural crops. And the subsection 3, again, is another important thing that came about as these statutes came to come into existence, is that an individual is not criminally liable solely because of the individual's status in a business, organization, or other public or private entity, nor is knowledge possessed by an individual other than what is actually attributable to them. So just important to note that those are some of the contexts that we look at who is responsible. Really quickly, there's statutes within this that indicate an important fact for how we review these things. So notwithstanding ORS 161067, which is the traditional criminal statute that defines the number of incidents that can occur in if you're looking at charging instruments, how many criminal instances there are. In our environmental context, each day on which a violation occurs or continues is a separately punishable offense. So for all of the sort of traditional buckets of criminal prosecution that I list there, if something is ongoing over a long period of time, that technically each day can be a separately punishable offense if the evidence shows that that activity was happening on the day. Now, is that going to happen in every prosecution? No, any DA will tell you that they're going to choose their number and type of charges based on what works for them, what tells the story that they need to tell. But it is something that can be a powerful thing, especially when an incident is so ongoing that the harm grows exponentially with it each growing day. And it's just another sort of tool in the toolbox of prosecutors when looking at these cases. So hazardous waste, we included these in the conversation about illegal cannabis just because it may come into play with, and we'll talk a little bit about pesticides later. It may come up in the grow context, but another thing that is on the radars and the concerns of law enforcement that deal with these cases is also the butane, hash oil, and other cannabinoid extract process. Those entities and those who work in the fire realm know that the concern there is that such operations, especially when operating far outside of whatever legal responsibilities they could have safety concerns that can include explosions and fires. We are working with DEQ and other partners to make sure that when those businesses, both legal and illegal, have hazardous waste or hazardous materials and chemicals in the part of their process, that they should and do know about their responsibilities under RCRA and other hazardous waste statutes in Oregon. Essentially, the misdemeanor criminal charge here, a person commits a crime of unlawful disposal, storage, or treatment of hazardous waste in the second degree if the person in violation of that all means essentially the hazardous waste statutes in Oregon, in violation of that statutory scheme, knowingly treats, stores, or disposes of hazardous waste. An important note for all of these misdemeanors is that they've been taken out of the normal misdemeanor fine schedule that traditional A, B, and C misdemeanors have, and the A misdemeanor or the B misdemeanor here has a fine up to $25,000. That is something that we think is really important, as this may apply to whether or not prosecutors can or choose to include these on charges relating to cannabis, because it is an additional hammer to, even though it may be a misdemeanor, can increase the amount of sort of penalty or appropriate response for sentencing and that type of thing that may not be possible with other misdemeanors that they would be looking at in a more traditional sense for their cases. First degree, the additional thing here essentially is that it's the same misdemeanor language of the previous charge, but at either as a result of their sort of violation of the previous statute, recklessly causes that substantial harm to human health or the environment as that definition that we previously showed you, or knowingly disregards the law in committing the violation. Now, that second subsection is probably the one we see more commonly in our realm, because it comes up when a regulated entity that is well aware of its responsibilities sort of completely disregards them in choosing to either continue some action or do something else. That's that level of severity, that additional action that makes a felony charge warranted. The recklessly causes substantial harm to human health is something that we do believe may be happening or showable in cannabis prosecutions, but that we just want to make sure that when we're using that basis, that we have plenty of evidence to be able to show that. And that's where our community partners at ODA, DEQ, Water Resources, and any other state agencies or other partners as a part of that they will be an instrumental part in being able to answer that question if and when it happens. And we just want to make sure that it's used appropriately so that that definition sort of maintains as much teeth as it can as applied over time. And again,
I think it's good for the committee to understand when we're talking about felonies, whether it's hazardous waste like we're talking about now, or water pollution or air pollution. The two routes to getting to a felony, it is a high bar. To have both a knowing discharge and a knowing disregard of the law, there aren't a lot of other criminal statutes where you have to know you're violating the law in order to be charged with it. Most often it's the act and a mental state that results in the charge. So that's just one thing to think about when we're looking at felonies in this environmental context.
So, question for you. I mean, it sounds like, listening and reading between the lines, that was a political negotiation to have the knowing disregard of the law as the state was moving in toward identifying environmental laws or environmental crimes. Is that inappropriate in your view?
No, I think it's entirely appropriate. Given what we have said earlier about multiple avenues to enforcement, right? That we have there, that the agencies will have existing civil authority, that we have criminal authority both in misdemeanors or these statutes in the second degree, whether it's hazardous waste in the second degree, water pollution in the second degree, or air pollution, and then you have the felonies. I think that it's important that the felonies are saved for the most egregious violators. I don't want it to be seen by the subcommittee as a complete barrier to enforcement. I think there are other avenues that we have when we think about how cases are developed that probably are more significant barriers to the way cases come across our desk than our ability to prove that. I think the investigation part is far more important than the way the existing law is written.
Okay.
So Representative Marsh, this is Lauren, and I'm sorry if my camera didn't want to turn on, but an example of that would be in our pesticide program. We have the ability to administratively assess someone a gross negligence violation, which has a much higher claim, but it stops short of this paragraph. We've also had some that go way above beyond even gross negligence and that might fit into what Patrick and Jordan, but there is that fine line between that. And if I could ask a question here, Patrick and Jordan, can you tell me if someone's already like an illegal cannabis grow, I mean, they're illegal, just they don't have a license from either agency, they're illegal just to start with. Does that play into this at all in the knowingly disregards when the whole activity that they're doing isn't legal to begin with? Forget whether they've actually done an environmental piece. Is that a first step to that? If my question makes any sense.
It does, and Patrick, I can take this one.
Yeah, absolutely.
It's you bring up a good point that in terms of that knowingly disregards factor for the utilization of a felony on illegal cannabis, it may be difficult for prosecutors to prove that someone who went into a situation without any sort of pre-existing intent to abide by the law in doing it may not have done any research or have any pre-existing knowledge about environmental statutes, especially if it's someone in the realm of either an out-of-state or foreign national that's operating illegally within the state. So in that sense, as these felonies could apply to environmental prosecutions, we would much more be thinking about capturing the evidence about the harm and having that conversation. However, where we're currently at, because this is the first time that we're truly taking a look at how environmental statutes can play into this realm, as everyone in this subcommittee and all of our partners in this know, is that the cannabis industry has changed so much every year very rapidly, and it's only as those years go by, we figure out better ways to address them from investigatory standpoints, from enforcement standpoints, from all of these variables. And why we think that at least even these misdemeanors are appropriate is that what it can do, the misdemeanors are not a high bar to add to some of these cases. They can be fairly easily added when the proper documentation and evidence collection happens on these sites. It's and that gives the opportunity that along with whatever felonious drug charges they're going to have, gives that prosecutor a chance to make sure that juries are understanding what's really going on. As I said earlier, whether or not there's something additional that could be thought of that makes felonies more applicable to these, that's something that we haven't considered at this point, because right now we're making sure that we understand the best ways to utilize them now. It is certainly a question we could think about as we capture a sense of truly what the scale of the problem is as we reach out to our partners. But as of now, we think that the existing tools seem to be working. We're trying to educate those so that we can utilize what's on the books now before we think about a way to either add or modify, because we would not want to do something that could disrupt how the statutes may apply to non-cannabis situations. Whether there's a cannabis-specific version that could be added, that's something we haven't yet considered, but we are certainly open to just discussing with groups what could be improved. We're more in that exploratory phase at this point of how do we use the tools we do have.
Yeah,
at least in terms of that felony context.
So Jordan, can I restate what I think I heard you say, which is that knowing disregard is not supported by just being an illegal operation, but as we operate within this environmental crimes realm, knowing disregard has to address specifically the activity that resulted in the environmental degradation.
While I can't speak for every case, obviously every investigation is going to be looked at individually. My personal view on whether or not my personal view would be being an illegal entity alone would not satisfy that subsection. Patrick can highlight that, because I think it's certainly they may have, even if they knew the law, that would be the first thing that that a prosecutor would have to prove, is that they knew the law, because in looking at the definition of the word disregard and thinking about that concept, is that it requires at least some sense of previous knowledge and or a responsibility that they should have known.
Understood.
This may be a different conversation if we were talking about a licensed or legal cannabis operation that was in some way acting far outside of its responsibilities. That is something that we given the vast amount of education available to legal growers, that may be something that we could talk about in that sense. But in terms of illegal cannabis grows, that would be something that a prosecutor would have more difficulty proving, is that they had any previous knowledge and that disregarded that knowledge.
So Representative Marsh, thank you for your clarification. You asked what I was just about to ask, because I think generally the people like me, and then I know I've had several discussions with legislators who are having a hard time understanding how you can go into an activity totally blatant and illegal and not have everything else behind it follow it. Your explanation, I think, makes sense to me. We just need to make sure that others understand those nuances, because I think there generally is a perception that once you start out very illegal, you don't even pretend to try to do things right, that if you're doing anything environmentally, that is all of a sudden unknowingly. And your explanation makes sense to me. And it'll be up to the legislative leaders, obviously, to figure out if they want to do anything with that. But I hope that explanation helped Representative Marsh. I know you get it. It's just others that I've talked to, and I couldn't explain it. So
Yeah, totally. No, it's super helpful.
Yeah, thank you both. And just to add one piece to that I believe would be helpful is a reminder that these statutes were not written in the world of legal cannabis. This statutory scheme was set into motion far before the state ever had to grapple with some of the issues that it's now come to grapple with in terms of this realm. So I appreciate those questions, and that they highlighted an important variable that we think about when evaluating these things.
Well, and your point that it wasn't written for illegal cannabis. I mean, one implication there is that maybe it needs to be changed because of illegal cannabis, but the other implication is there are other settings to which this applies. And as you stated earlier, you have to be cognizant of making changes for one purpose that upset the application in another realm.
It's true. And as Patrick and I have said, as we've talked about these things, that we are working hard to learn the best ways to do this, so that if and when there is a change, that we would suggest that it can be backed up with some concrete examples, some other community partners who we've been able to discuss those with, and certainly something that is in our mind as we start to operate in this area. I want to get to some water pollution conversation, because I think it's important for this group as well. So I'll move pretty quickly. The unlawful transport and hazardous waste, second and first degree, mimic the ones we already showed you, but it's just about transportation. So this just could apply to another sort of piece of the puzzle in terms of those who are involved with various types of cannabis operations. And again, those same factors are what increase it to a felony. So I'm talking about water pollution. I want to go through some quick definitions of how we look at these things. This pollution definition is a fairly wide one under the water quality statutes, and what that allows us to look at in terms of the illegal cannabis realm is that it's not purely chemicals or other sort of adulterants introduced to water that may constitute pollution of that waterway. Other aspects of that activity, including changing the temperature, the turbidity of the water, their activities around the water sources that they may be using, or as Jake is intimately aware of, obtaining water illegally from. Some of that activity may technically meet this definition of pollution, even if it's not what most people would think of in terms of the pollution of a waterway. So that definition is important as we've looked into this context. Again, that same thing with waste is that it could be all sorts of things, including sort of plant material as they go through their process of curing and prepping the cannabis for their end product. The other important thing that makes our work in this realm important is that the definition of water and waters of the state in Oregon is much more expansive than that of the federal definition under the Clean Water Act, and therefore gives us a chance to be able to look at the question of whether or not water pollution occurred on some sites in a way that some of our federal partners may have not been able to enter, especially when it comes to the conversations around groundwater or other types of waters in the state. It gives us an additional, again, opportunity to have effect in this realm. Something that question still has to be answered as we address these things. We need to be able to make sure that we are confident that it meets this definition, but we are fortunate that that definition is more inclusive in Oregon than it is from the federal perspective. Where am I? Okay, there we go. So water pollution in the second degree, this is definitely a charge we think is most likely to come up in the traditional GROW context. Person commits the offense of unlawful water pollution in the second degree if the person with criminal negligence violates the water quality statutes or any rule, standard, license, permit, or order adopted under the water quality statutes. And again, it has that increased fine schedule that is unique to the statutory scheme. In terms of the felonious standard, it is, again, it mimics that structure that we showed before. Commits the crime of unlawful water pollution in the first degree if that person, in violation of the water quality statutes or rules, knowingly discharges, places, or causes to be placed any waste into the waters of the state, or in a location where the waste is likely to escape or be carried into the waters of the state, and again, either as a result recklessly causes substantial harm to human health or the environment, or knowingly disregards the law. An important other distinction between the misdemeanor here, the second degree, and the first degree is that in this misdemeanor, the standard is if the person with criminal negligence. Now that is for a prosecutor is likely the most exciting mens rea to work with, just because it is the one that gives you the most latitude to consider that criminal activity. It is the lowest mens rea bar that we frequently deal with in that criminal realm. And even though obviously we still have to prove that beyond a reasonable doubt, it's one that gives us a little more latitude than the knowingly discharges that's in place in this water pollution statute for the felony. I include this statute because it's probably this statute's or this statutory scream's heaviest hitter for us. It obviously does not come up much, and once I read the language, you'll understand why. But again, we think about situations where illegal cannabis activity may result in explosions that could harm people or something along those lines, that this conversation could come about. A person commits the crime of environmental endangerment if the person knowingly commits the crime of unlawful disposal, storage, or treatment of hazardous waste in the first degree, transport of hazardous waste in the first degree, unlawful air pollution in the first degree, and unlawful water pollution in the first degree, and as a result, places another person in imminent danger of death or causes serious physical injury. Again, this is a high bar for us, but it is obviously reserved for the types of situations where something catastrophic has happened. But even in Jackson County, we can think of situations where individuals were harmed due to fires or explosions that have occurred as a result of illegal BHO activity. So something that I just want to put on that radar, and something we want to expose law enforcement and our DA partners to, because while it may not come up very frequently, and we obviously hope that it doesn't, we do not, if Patrick and I had our way, we would be out of work because there would be no environmental harms going on. But unfortunately, that's just not the case, and we want to make sure that our partners are aware that there are some serious implications in our realm as well when that situation does arise. This is an interesting one I wanted to make aware to this group, is supplying false information to an agency. Now, currently, this isn't going to apply to cannabis cases, but I want to put the language on the radar. A person commits the crime of supplying false information to an agency if the person makes any false material statement, representation, or certification knowing it to be false in any application, notice, plan, record, report, or other document as required by essentially the environmental statute. So that includes water, air, and hazardous waste in terms of those ORS chapters. But this does not apply to a situation to in which someone submitted false information because on an OLCC, ODA, or OHA submission. Now, whether or not that's a change that is appropriate is something that should be discussed, and I think that I would be interested to hear what partners think about that concept. But as a whole, it's not something we deal with now, and whether or not the same penalties are appropriate can be discussed. But for us, this statute is important because in the environmental context, many programs rely on the regulated party to be honest and forthright with information that happens. Partners in the regulated community are supposed to be at the table in terms of how some of these things occur, but it's when evidence surfaces that they have been dishonest is one of those things that brings it much more squarely into Patrick and I's realm. When someone is engaging in activity that obfuscates the truth so that they can either gain a material benefit or avoid detection for whatever activity has or is going to happen, that makes something much more serious and is much more something that the criminal investigators are interested to know. Again, just something I want to make sure was on the radar of this.
I think Jordan makes a really good point here. You know, when we think about the DEQ context, right? DEQ writes permits for the entities that it works with, and those entities have to submit information to DEQ. And so a lot of, the entire enforcement program runs on making sure that that's done correctly. And so that's why, making a false material statement or omitting something on it is a felony, because we rely on the permittees to do a lot of their monitoring.
But those are permittees that are ostensibly legal.
Yes,
as opposed
absolutely.
to permittees that begin out by being illegal. They're really not. So this has probably less application to our realm.
Certainly in the unlawful cannabis context, and it doesn't currently apply as written statutorily to the permitted cannabis, but it is how enforcement works in the DEQ realm. So I think it's important for the subcommittee to think about that as you think about OLCC, ODA, OHA, and growing an enforcement program in a different realm.
Got it. Thank you.
And again, another just interesting one that may sometimes come up, but again, is probably something that would, as of now, come up only in a permitted cannabis investigation if something were to happen, is refusal to produce books, papers, or information subpoenaed by specifically EQC or DEQ or the Regional Air Quality Authority can be criminal. Again, not something that applies too much, but again, if for some reason that a legal entity is doing something that requires their DEQ permits and they are not complying with the responsibility to their regulators, in the perfect world, people work with their regulated communities and with their regulators, and when they don't do so, that penalties can ensue. So those are at least the parts of the environmental crime that we think are most applicable to cannabis. There are other potential opportunities, and we can go over those kind of at the end, but we just want to give a brief overview. And again, there's much more to it than that. So if there's other questions, please feel free to reach out. So we're going to.
I want to do just a quick time check, because unfortunately we have our main task force starting at 10 o'clock. So we only have another 5 minutes here.
Oh, that's okay. I can cruise in 2 minutes to get to some questions.
Go for it.
So these are just the statutes that Jake and his partners have been working on. This is some unlawful use or appropriation of groundwater. This group is obviously intimately aware of HB 4061. I highlighted essentially the what criminally changed as a whole when that passed. So in this group is aware of that, and if anyone wants this information, happy to reach out after this. What I wanted to highlight is what we have done this summer so far to start helping those partners. eCrew has had multiple discussions with water resources and our other DOJ partners that help them in regard to the impacts of this case. We've started to have conversations about what generally how DAs and investigators think about search and seizure issues, about the criminal process. We're already going to be doing a training with Water Resources in November to start helping their new hires be educated as to what some of those questions are, or how the criminal arm of things look at these problems. We're also doing work to connect water masters to their local DAs and law enforcement teams. We've been very happy to already see Water Resources and local law enforcement partners further sort of bona fide their relationships, and some of this has been happening organically, and we're just excited to help be a conduit to help that happen. Much work left to do with Water Resources, but also we have been excited to have many in-depth conversations with them about how we can all be good community partners and help this process. And we've talked about pesticides. The thing to note in pesticides, there's I think much to think about how prosecutors could properly use this statutory provision. So under the pesticide control statute, there is a criminal provision that basically says any of the provisions of this chapter is a Class A misdemeanor. That opens up a wide variety of things that could be technically considered a misdemeanor violation of pesticide control. Not all of those things may add to the story that a prosecutor is trying to tell when they're prosecuting a drug case. There are certainly extremely dangerous chemicals and pesticides that are used on grows, and when that is there, this is a charge that I think should be utilized. However, there are also situations where someone is essentially engaging in something that many gardeners may be doing, and we're not trying to just blanket criminalize everything. It's not always going to add to a criminal prosecution. So our goal is to help educate prosecutors on how to use discretion in that. Their own experience is likely going to guide those things. But we have learned that ODA provides a lot of good resources for pesticides, and we've had some great conversations that have helped us learn how to better help our criminal partners in identifying when these things should be utilized. Again, I think we have a lot to learn in terms of how to best utilize what exists now, but there is possibilities, and we are spending time learning about sort of what can be brought more cleanly to a prosecutor's plate so that it could be added to a case when it does add to that prosecution. And again, this is just, sorry, go ahead, Patrick.
Yeah, really quickly, Representative Marsh, following up on your question earlier, when I think about, I think of two hurdles to aggressive environmental prosecutions generally, but also in this area. I think first and foremost, it's important for this. We talk about collaboration a lot this morning. ECRU works collaboratively with the state agencies, but there's no mechanism in place for learning about an environmental offender without a referral from the appropriate state agency. With one exception, there's no state level criminal investigatory agency that focuses on environmental enforcement. The exception is a lone OSP trooper who's assigned to and paid for by DEQ. Local law enforcement generally has less familiarity with the pertinent statutory scheme, and that can be a barrier to these investigations. Now, as Jordan's mentioned, we're doing a significant amount of outreach, training, and collaboration in order to identify partners in that stuff. But I think it's important for the committee to note, with the exception of DEQ, ECRU only learns of potential criminal cases if and when the applicable agency notifies us. And Sunny and ODA have been great partners, and Jake and Water Resources have been great partners, and we continue to look forward to working with them in that area. But I think that's important for the subcommittee to know. And then the other part that I think is a barrier is even when a case is referred to ECRU or a DEA's office, it can be that courts rarely impose significant penalties. And there are two factors that can result in what we would think of as a weak criminal sentence in an environmental case. I think first, courts are accustomed to imposing significant sentences against violent offenders, but they're unfamiliar in territory when sentencing an environmental defendant. And second, even if an environmental offender receives something like a jail sentence, some form of incarceration, most counties, as we all know, suffer from inadequate jail space. And violent offenders clearly and rightly receive priority when it comes to custody units. So that often means, when we think about trying to get other significant penalties, why the civil realm also gets used. So I think it's important for the subcommittee to think about those two factors when we think about both environmental enforcement generally, but also in this realm of cannabis, and why we talk so much about working collaboratively with our agency partners.
Well, that was really a great education. Thank you. We are unfortunately going to have to abruptly end the meeting because we have another meeting happening, but I would love to continue to pursue this and bring in our local DAs, maybe in Jackson County, and just get a perspective there in terms of their ability to access any of this additional, additional law enforcement strategies. And I would also
being a part of any conversation.
We can
Okay.
help you coordinate with them as well. Thank you,
Okay.
Ms. Marsh.
Great. Thank you all. Thank you for being here. We will reconvene when Sunny tells us to reconvene. Thank you.
It's August 5th from 1 to 2.
Perfect. And again, Patrick and Jordan, thank you so much. Super helpful.
You're
Thank
most
you.
welcome.
Thank you very much.
Bye.